not just constitutional amendment cannot be violative of the basic structure, and point out there are two direct judgments that even acts on the standalone basis can be challenged on the ground that they violate the basic structure. And Coelho, now 9 judges of my Lord's Court, have upheld the same. Now, there are observations that 31C also this will apply in Coelho itself, but that issue did not squarely arise here.
Last two orders which you have shown us,
Lordship.
7 judge,
Lordship.
and then of 5.
Lordship.
The two orders really dwell on 39B.
Lordship.
There is really no reference to 31C.
Lordship.
Or nor is that point specifically referred to the bench of
Except in para 6, insofar as they say await Coelho. So Coelho would then be that are those rights available?
Because they probably wanted to await Coelho because another 9 judge.
Coelho must have been, my lord, on the anvil of being listed.
It has some impact
On the anvil of being listed. That appears to be.
No, I was also appearing in Coelho. It was not on the anvil of being listed. But we pointed out that the same issue arises there in the context of 31B. That even if you put that act in the 9th schedule, you can still challenge it on the ground of violation of the basic structure. And that's the issue we raise here also, that even if it's protected by 31C and we fail in all our other contention, it is still open, and that's the short issue we want your lordships to consider.
So why does a bench of 9 have to consider that issue?
Because, in fact, the Coelho reference order explains that, but Coelho, as 9-judge bench, decided this issue for 31B. So we'll indicate, my lords, as we...
It's very tenuous, like that.
It is, to that limited extent, yes. But, my lords, we are... Just give me a moment. Correct.
I mean, that is the point that I...
Three ways we also discussed that. May I just... There are, so lordships, I'll just submit there are 2-3 possibilities. I'm not... Lordship, so I may just, this is what we consider, my lord. I'll just place it before you. And then you may consider as you, my lords, may.
It's not the ambit of the reference.
Lordships, I'll do that. But we thought there were three possibilities that arise in this case.
Yes.
The two judgments, Sanjeev Kok and Abu Kaur Bai, are 5 judges. Ranganath is 7 judges. But Minerva, the Mafatlal judgment is 9 honorable judges. Now, if my lords either can hold that Mafatlal is arbiter, then it's open to my lords to decide this issue. Otherwise, my lords may have to consider whether it has to go higher to a 11-judge bench. In case my lords is not in, doesn't hold that Mafatlal was arbiter and it's clearly arbiter, we'll try to make that good. In which case, it's open to my lords to decide this matter, is our first submission. Tell me, what is this? Lords will consider whether on Mafatlal issue, my Lords wants to consider that and will make it good that those were arbiter observation. It had nothing to do with the issue at hand. Or it should go higher. That's one issue that my Lords will decide. On 39 BNC, my Lords, we are with my Lords. That if 39 BNC is decided, it can go back to 5 judges for consideration on 31C, whether it survives or not. But we would like to make our submissions on Coelho, because Coelho specifically deals with the scope of challenge under 31B and C. Although 31B arose there, we do want to make our submission that the same principle will squarely apply for 31C. Because if it does, then my challenges under 14, 19, 21 are still available, even for these laws, even if protected under 31C.
Then you can also argue that before.
We can. Lordship, we can.
3 judges or 5 judges.
I will not disagree. My Lords is right. So, but we like to place Coelho, and then my Lords may take a view on
Alright.
my Lords.
So now how do you want to begin?
No, my Lords, so we've drafted some propositions. I'll briefly indicate what all arises. Not all of this has to be decided by my Lords, but we'll just place what we wish to argue. Huh. Seeing those issues, and then if my Lords permits, I'm proposing to read the Malpe judgment and then hand it to my colleague, Chandrachud. So these are the two aspects. So may I just indicate these are the issues that we feel arise. Most of them, of course, will not be have to be considered by this bench, but I wanted to place these on before my Lords. The first is whether Article 31C of the Constitution of India survives after the judgment of this Honorable Court in Minerva Mills in so and so, striking down Section 4 of the 42nd Amendment Act. Now, whether Chapter 8A of MADA has received the assent of the President of India as required under the provision of 31C and as decided by the judgment of this Honorable Court in Kesre, that is, reasons were given, etc., and they did not produce that. Whether the onus of proving that the assent of the President was in compliance with Kesre is on the